Judicial concerns now. The legality of Deputy Chief Justice Philomena Mwilu acting as Chief Justice in David Maraga's absence has been challenged in court. Okiya Omtatah is back in court, this time contending that the Constitution does not provide for an acting Chief Justice. He also argues that the Deputy Chief Justice can only step in the case of death, a resignation, or removal. Olive Burrows has the details.
Monday was Deputy Chief Justice Philomena Mwilu's first official day in office as acting Chief Justice. Chief Justice David Maraga having authorized her to act in his stead for the duration of his terminal leave. But the legality of his action has been challenged in court. In court filings submitted on Monday, serial petitioner Okiya Omtatah contends that the Constitution does not provide for the position of an acting Chief Justice. He also makes the case that the Judicial Service Commission Act, Section 5(4), only provides for the Deputy Chief Justice to act in the event of death, resignation, or removal. When the Honorable Justice retired, Dr. Willie Mutunga vacated office due to the lapsing of his term. No acting Chief Justice was appointed. The office remained vacant until the Honorable David Maraga was recruited and appointed as the substantive Chief Justice according to the law. Omtatah has therefore moved to have the court quash the letter by Maraga authorizing Mwilu to act on his behalf.
In that scenario, there's a period when there's a lacuna in terms of the administrative role of the Chief Justice. And that is what is very, very, very untidy. And basically then what it means is that you need then to hasten the process of the appointment of the Chief Justice. Otherwise, you could end up having a serious crisis in the judiciary in terms of leadership, because all other judges are equal.
And it's exactly the kind of scenario that the Judicial Service Amendment Bill 2020 seeks to remedy by requiring the recruitment process to begin 6 months prior to the term of the Chief Justice expiring. In the present case, Maraga squashed efforts to start the recruitment in anticipation of his retirement, a move that divided not only the Judicial Service Commission but the Law Society of Kenya as well.
I think it doesn't take even basic intelligence to know that if someone's office is coming to an end as a matter of law, the earlier you start the process of recruitment, the better. You know, you do not want the sort of gaps that are there in terms of succession to happen. And you know, so I find it unfortunate that we're even having a conversation about whether we should start recruitment early.
Timely recruitment is also intended to ensure the 5-judge minimum at the Supreme Court is never in jeopardy. With the retirement of Justice Jackton Ojwang in February and Maraga out on terminal leave, the court is down to the wire as Mwilu fights off the stink of suspected corruption.
It is not enough to charge them with an offense and then they leave office, because that can open the possibility of that power being misused. You require a very comprehensive process, including the setting up of a tribunal, and then it's only thereafter that one is suspended. Now, of course, the converse is also true, that because that process can also be stopped by the courts, and the courts and the person who is under contention is a member of the judiciary, that can also lead to the misuse of the court powers in terms of suspending those sorts of processes. And that sort of delicate situation will have to be resolved with time.
With only the second Chief Justice exiting office under the current constitutional dispensation, the precedent continues to be set.
When in an ideal world, if there is significant evidence that you have committed a crime, that there is probably merit, even you as a person, being able to step aside to allow for that process to continue and be concluded, because ultimately what that does is that it raises the integrity of the institution as a whole.
Olive Burrows, NTV.